Hello everyone, and thank you for joining me for Michigan PIP Monthly June 2018, a complimentary Seacrest Wardle podcast where we discuss updated case law in Michigan no fault as well as trending topics of interest in the law. Many of our trending topics come from just things that we've encountered throughout the month or topics that are suggested to us by some of our clients. My name is Javon David, and I am a partner at Seacrest Wardle. I'll be presenting the Michigan PIP Monthly today. If you have any questions afterward or any comments or would like to pitch a topic, you can contact me at the contact information listed on the last slide of this podcast series. In June 2018, there was not much traffic in the Court of Appeals. There were many cases that came down, but not too many pertaining to Michigan no fault. So I'll talk about two of the cases that are of significance that came down that may be relevant to you in your claims handling on a day-to-day basis. So the first case is the Vandercook versus auto owners. That is a case involving no fault and case evaluation. I'll also talk about Foote versus Memorial Hospital, which is another case that has come down, or an order actually that has come down regarding the Covenant case that we're also familiar with. Then I will discuss the trending topics in no-fault litigation, the Medicare Secondary Payer Act, overview, no-fault interplay, meaning a lot of questions that we get about Medicare and no-fault, and double damages that we are now seeing more frequently than before asserted by plaintiffs in complaints and in just their demands for payments. Now, the first case we'll talk about today is the Vandercook versus auto owners case. This is an unpublished opinion that was issued May 24, 2018, arising out of a 2014 motor vehicle accident. Plaintiff filed a lawsuit for breach of contract claiming various no-fault benefits, including lost wages, replacement services, and various other benefits under the No-Fault Act. In the course of litigation, the case was submitted to case evaluation, as they often are, and plaintiff's case evaluation summary listed medical expenses totaling $93,000. This included medical expenses and family-provided attendant care only. In response, defendant argued that it properly paid all reasonably necessary PIP benefits and challenged the specific benefits demanded by plaintiff. Ultimately, the case evaluation panel awarded plaintiff $45,000. Defendant accepted the award. Plaintiff also accepted the award, but typed into the form that he accepted the award as to benefits referenced in plaintiff's case evaluation summary only, not including wage loss. After learning of the mutual acceptance of the case evaluation award, defendant moved for clarification from the trial court as to whom the proper payees were for payment of the case evaluation award. Plaintiff responded and failed to cite any legal authority, stating that he conditionally accepted the award as to bills specifically referenced within the summary. In reply, defendant maintained that MCR 2.403 does not allow for any such limited acceptance, but rather governs the entirety of one's claims asserted in a lawsuit. Specifically, the defendant advised the court that mutual acceptance of case evaluation resolves all claims through the date of case evaluation. There were various motions filed by the parties, but ultimately plaintiff argued that a separate lawsuit had been filed for benefits not including the prior case evaluation. Defendant did not waver from its position that plaintiff's actions were not allowed, and ultimately the trial court upheld plaintiff's limited acceptance, prompting the appeal. So essentially the trial court said, yes, we're going to uphold the fact that you wrote into the award that it was conditional and that it was lacking the wage loss portion of the claim. Defendant appealed that ruling. The Court of Appeals panel examined 2.403 and the controlling case law. It noted that if all parties accept the panel's evaluation, then the case is over, citing a case called Cam Construction versus Lake Edgewood, which is a 2002 Michigan Supreme Court opinion. Further, the court held that the purpose of case evaluation is to resolve the case, not to bifurcate litigation or decide it on a piecemeal basis. Additionally, the court examined plaintiff's complaint and highlighted the fact that it did not carve out any specific no-fault PIP benefits that were not being claimed in that action. Specifically, plaintiff's complaint plainly did not limit his civil action to the benefits he listed in his case evaluation summary. In other words, the plaintiff didn't plead in his complaint and say, this action is limited to everything that I will be submitting at the time of case evaluation. Instead, they said this is a claim for first-party benefits, as we often see. Ultimately, the court held that plaintiff had no option or right to limit his acceptance of the case evaluation award. In addition, pursuant to the court rules MCR 2.403 M1, upon acceptance of both parties, the trial court must dismiss the action with prejudice, and the judgment or dismissal shall be deemed to dispose of all claims in the action. Accordingly, the Court of Appeals reversed and remanded the matter, finding that the trial court erred in reviewing plaintiff's case evaluation summary to even allow him to bifurcate the claims that were accrued before the case evaluation hearing. So lessons to be learned from that case is if a matter is submitted to case evaluation and resolved by case evaluation, then that resolves the claims from the lawsuit. You can't say that, I only intended to include X amount of bills, or I didn't include wage loss in my claim. I'm going to file another lawsuit about that. No, it's everything that you submitted and that you presented as part of your first party claim throughout the course of litigation. So your first party claims were barred at that point. The next case that came from the Court of Appeals in the month of June was not necessarily a case, but an order that we should all be paying attention to and watching. And of course, once the opinion and order comes down, we'll issue a no-fault newsline for you to review, and we'll also do a podcast series on that particular case. But W.A. Foote Memorial Hospital versus Michigan Assigned Claims Plan had an order come down indicating that the retroactive application of covenant may again be in controversy. A year ago, May 25, 2017, the Michigan Supreme Court released its long-awaited decision of Covenant versus State Farm. Of course, the issue presented in that case was whether healthcare providers had an independent cause of action against insurers under the Michigan No-Fault Act. The court held that under the plain language of the Michigan No-Fault Act, a healthcare provider does not possess a statutory cause of action against a no-fault insurer for payment of no-fault benefits. Following this ruling, the Michigan courts and appellate courts struggled with the questions about whether or not providers have standing in the wake of this ruling, leaving many inconsistent rulings across the board. In addition, there have been controversy as to whether or not Covenant's no statutory standing rule applies to provider suits that were pending as of May 25, 2017. Most recently, the Supreme Court issued an order in the W.A. Foote Memorial case indicating that the retroactive application of covenant may again be in controversy. The Supreme Court is going to hold oral arguments to consider whether it will review Foote Memorial Hospital again. This is not a reconsideration of covenant, but the court's opportunity to determine if covenant's no statutory standing rule applies to provider suits that were pending as of the date that they issued their original opinion. After arguments, the court may still decline to address the merits, but it is estimated it could take about 6 months before oral arguments are heard and almost a year before the Supreme Court makes its decision in finding covenant to be retroactive or not. So we were asked to discuss the Medicare Secondary Payer Act, just kind of provide a general overview and discuss some issues that some of our clients have had, especially most recently from either pre-suit or in the claim stage with the issue of double damages or whether or not the one-year back rule applies. So the Medicare Secondary Payer Act, as many of you know, makes Medicare the secondary payer of medical expenses when a beneficiary has other sources of primary insurance coverage. Specifically, the MSP provides that a Medicare payment may not be made with respect to any item or service to the extent that payment has been made or can reasonably be expected to be made under a primary plan. No-fault insurance is included as a primary plan under the Medicare Secondary Payer Act. So Medicare is able to make conditional payments for services when the primary plan has not made or cannot reasonably be expected to make payment with respect to such an item or service promptly. Medicare may seek reimbursement from the primary plan if it had a responsibility to make the payment promptly. Importantly, if Medicare is not timely reimbursed, the MSP, which is the Medicare Secondary Payer Act, establishes a private cause of action to enforce the reimbursement provision by seeking double damages against the primary plan. that is twice the amount of what was paid by Medicare. So if Medicare was paid $7,000 on behalf of a claimant, they can technically claim $14,000 under the federal statute. So what has to happen to allow them to invoke this cause of action? Well, in order to do so, Medicare must have actually made the payments on a beneficiary's behalf, and the insurer must be responsible for making those payments. So the no-fault carrier must have been found to be responsible for making those payments. Responsibility is demonstrated by various things that are specifically defined in the Medicare Secondary Payer Act. The responsibility is determined by a judgment, settlement, by a primary payer, or by other means. And that's 42 USC 1395. Now, the issue of whether or not a person is able to obtain double damages, as it's referred to, for an insurance company's failure to pay the benefits is valid. Yes, the private cause of action where a Medicare beneficiary can use an applicable plan to recover damages is a valid cause of action that's specifically provided for in USC Section 1395. And it specifically states in there that there is established a private cause of action for damages which shall be an amount double the amount otherwise provided in the case of a primary plan which fails to provide for primary payment or appropriate reimbursement in accordance with the remainder of the statute, which I won't go through here because it's pretty lengthy. But the short answer is yes, a person can be entitled to double damages under the Medicare Secondary Payer Act for the amount that was paid on their behalf and was not paid promptly by the no-fault insurance carrier. But let's not get too excited here. There are some things that need to be done in order for that to happen. So the private cause of action has to be ripe, and that is something that's often overlooked. I've seen and I've had my clients ask me, okay, I just got this letter from the plaintiff attorney and he's saying that he wants me to pay X amount of dollars plus double that amount because it's Medicare, so he wants double damages. Well, not so fast. You have to, establish that the obligation to pay has already been established either by settlement or some sort of judgment. And typically, even if you have some sort of settlement or judgment, you work out, or your counsel should be working out the language of Medicare issues in that release. That is what's going to protect you from having to pay double damages on a claim when Medicare is involved. So the language in the release is important because it will typically have the plaintiff say, I'm releasing this no-fault carrier from any double damages. I'll be responsible for them. So if and when a private action is ever pursued by Medicare as a subrogation claim for any outstanding amounts, you've already been released from this and it's not your obligation anymore. So a cause of action typically isn't ripe until the Medicare beneficiary, meaning the claimant, settles their underlying case with the defendant, and at that time the plaintiff is going to indemnify the defendant. So in essence, even if the plaintiff could collect based on a private cause of action, they're indemnifying for MSP obligations and attorney fees changes that paradigm where it is the plaintiffs who would ultimately lose out rather than the defendants when playing on the plans for settlement. So the bottom line is that, yes, a private action is real, and it is a real threat if you're not careful in the handling of a claim involving a Medicare lien or any kind of potential Medicare lien. You always have to find out if Medicare has been paying payments, and quite frankly, it's not only the claimant's obligation to put you on notice, but it's the carrier's obligation as well under the statute. And so, yes, the private cause of action is a real threat, but it may not truly be practical in most cases or in a typical settlement scenario. So the cause of action has more to do with, whether or not your client's case goes to trial and you receive a verdict on that and there's a Medicare lien involved. At that point, since there's no corresponding indemnification agreement or release of all claims, including a Medicare paragraph protecting the insurance company, then double damages would likely be the case. So I would say that the greatest risk for double damages is if you have a verdict on a first-party action involving Medicare. But if you don't, and you're in the process of resolving a claim for first-party benefits, then your release should protect you. and you should work out the terms of that release and be sure everyone's on the same page so that there's no issues as to double damages and no surprises down the line. We could sit here and talk about the Medicare Secondary Payer Act all afternoon, but these are the main questions that we've gotten from our clients, and these were topics that we were asked to discuss. If you have any questions about the case law or the Secondary Payer Act, feel free to contact me, Javon David, at Seacrest Wardle's Troy location. My contact information is on the last slide. Thank you for tuning in this month. If you have any questions or concerns, contact us. Otherwise, we will see you on the next show.